Hi everyone, I'm Panayiota Ioannou, the lead property litigation solicitor at Debenhams Ottaway. I'm joined by my colleague today, Alexander Neale, an associate in our insolvency litigation team. We're going to be talking to you today about the effect of insolvency on landlords. As it's a topic with many different issues to consider, we'll deal only with tenancies of commercial premises, whether they're occupied by an individual or a corporate entity, for the purposes of today's discussion. I can see that we have people listening in from various different industries, and we hope that there is something useful for each of you, even though it's difficult for us to cater for all of you. Our agenda today is that Alex will first take you through the various types of insolvency process and explain the impact of tenant insolvency. I will then deal with issues to consider when dealing with an insolvent tenant. You'll then be back with Alex to talk about alternative options available to landlords. And finally, I'll round off by considering how a tenant's insolvency can be an advantage. Time permitting, we'll then try to answer some of your questions at the end, but please do send them to us as we're going along. If you're experiencing any technical issues, please use the chat section. It should be to the right of your screen to let us know as we're going along. We are live today, so if we stumble over our words, please do excuse us. I'll pass you over to Alex.
Thank you, Annie. In the first instance, it's beneficial to go through the main types of insolvency that will be faced by tenants. In relation to individuals, there is bankruptcy. It commences with the bankruptcy order, which may be made against an insolvent individual, either on their own application or the presentation of a petition to court by a creditor or other party. The bankrupt's assets form their bankruptcy estate, which vests in, is realised and distributed to creditors by a trustee in bankruptcy, according to the Insolvency Act 1986 and the Insolvency Rules 2016. An individual voluntary arrangement is a statutory arrangement which allows a debtor to settle their outstanding unsecured debts by paying a proportion of that amount owed to creditors, allowing them to come to an arrangement with creditors over the payment of their debts. A debtor's IVA is supervised by an insolvency practitioner or other qualified person who acts as nominee for the debtor's IVA proposals and supervisor on approval by creditors. IVAs can be used as an alternative to bankruptcy, either as a way of avoiding a bankruptcy order or as a ground for annulling it. A debtor who proposes an IVA can seek an interim order granting them a break or moratorium from creditors taking action against them personally as well as their assets until their IVA proposal is considered and voted on by the creditors. In relation to company tenants, administration is a procedure where a company may be reorganised or its assets realised under protection of a statutory moratorium. The company is put into administration and an administrator appointed. At the end of the administration, the business has generally either survived and the company been rescued, or the business and the company's assets have been sold by the administrator and the administration ended in a liquidation or dissolution. A company may be put into administration by court order or by an out-of-court procedure available to the company itself, its directors, or a qualifying floating charge holder. Depending on how the company is being placed into administration, there will likely be an interim moratorium in place from the date of the filing of the notice of intention to appoint, alternatively any application made for an administration order. Liquidation is an insolvency procedure under which the assets of the company are realised and distributed to creditors by the liquidator. There are two modes of liquidation: compulsory liquidation following a court order and voluntary liquidation instigated voluntarily by the members or creditors of the company. Company voluntary arrangements, or CVA. This is a company equivalent to an IVA. The arrangement will be binding on creditors if the relevant majorities vote in favour of the proposals at properly convened meetings of creditors and shareholders of the company. Companies that are deemed small are granted a 28-day moratorium when a CVA proposal is being considered by creditors. We've now produced 3 slides with very brief background and breakdown of some of the potential remedies available to landlords and how they are restricted by the various insolvency processes. I will take you through some of these briefly before passing back over to Pani. In the case of bankruptcy, there is no moratorium when a tenant is in bankruptcy, which would prevent a landlord from forfeiting a lease by peaceful re-entry. In other words, the landlord can peaceably re-enter for non-payment of rent without restriction. A landlord is able to claim forfeiture by court proceedings or any other breach. A landlord can undertake the CRA procedure where the tenant is an undischarged bankrupt, but only for 6 months' rent accrued due before the commencement of the bankruptcy. The right to exercise CRA will cease upon the debtor's discharge from bankruptcy, which is normally 1 year after date of bankruptcy, unless the trustee has applied to the court to suspend the discharge. Depending on the terms of the lease, a landlord can draw down for the rent deposit, and the landlord can serve notice on the trustee in bankruptcy, requiring him to elect whether to disclaim the lease. In relation to IVAs, the position differs slightly depending whether the parties are in the moratorium period. During the moratorium period, forfeiture by peaceable re-entry or court proceedings, exercising QRA or drawdown from the rent deposit can only be undertaken with permission or leave of the court. Once an IVA has been approved, forfeiture by peaceable re-entry still requires the leave of the court. However, forfeiture by court proceedings for other breaches can only be used if there has been a breach of the terms of the IVA. A landlord cannot use the QRA provisions once the IVA has been approved, but the landlord can draw down from the rent deposit, subject to the terms of the rent deposit. In relation to administration, peaceable re-entry for non-payment of rent and/or forfeiture by court proceedings for other breaches requires the administrative consent or the leave of the court. QRA is not available during the interim moratorium without permission of the court, and it's not available after the administration order without permission of the administrator or the court. A landlord cannot draw down on the rent deposit without a leave of the court or administrator's consent unless the deposit is classed as a financial collateral arrangement. With regards to liquidation, the position differs depending on the type of liquidation. In a members/creditors voluntary liquidation, peaceable re-entry for non-payment of rent and/or forfeiture for other breaches are available. However, the liquidator can apply to the court to challenge this. Further, QRA is available, but the court can restrain exercise. Drawdown of the rent deposit is available subject to terms, and a landlord can serve notice on the liquidator requiring him to elect whether to disclaim. In relation to compulsory liquidation, peaceable re-entry for non-payment of rent and/or forfeiture for other breaches are only available with the leave of the court or the liquidator's consent. The QRA position depends on whether there has already been commenced, and it's best to seek advice. Drawdown of the rent deposit is only available with the leave of the court, and the landlord can serve notice on the liquidator requiring him to elect whether to disclaim. Finally, in relation to CVAs, the position is much like IVAs. During the moratorium period, forfeiture by peaceable re-entry or exercising QRA or drawdown can only be undertaken with permission of the court. Forfeiture for other breaches is not available, and drawdown of the rent deposit is not available without leave of the court or the CVA supervisor's consent, unless a deposit is a financial collateral arrangement. Once the CVA has been approved, forfeiture by peaceable re-entry still requires the leave of the court, and forfeiture by court proceedings for other breaches can only be used if there has been a breach of the terms of the CVA. A landlord cannot use the QRA provisions once the CVA has been approved, but a landlord can draw down from the rent deposit subject to the terms of the rent deposit.
You're now back with me, and we'll look at issues to consider when dealing with an insolvent tenant. As you will have understood from Alex, a tenant's insolvency will have an impact on a landlord and the remedies available to them, whatever the form of insolvency process. If a landlord becomes aware of a tenant's insolvency, then they will need to consider their next steps very carefully. Their immediate concerns will usually be whether the property is properly insured, whether they want to forfeit the lease, and if so, to stop any demands being sent out, whether they can demand that the rent is paid as an expense of the administration, whether they can exercise QRA, whether they can draw down money for arrears from the rent deposit, or require the guarantor to pay the rent arrears, and whether the landlord can require the guarantor to take a lease of the premises. In order for the landlord to carefully consider these matters and make an informed decision, they will obviously need to check the terms of the lease, the terms of any guarantee, and any rent deposit deed in detail. You should therefore make sure that you have these readily available. I'll take you through the insurance issue briefly first. If a tenant is insolvent and not trading, the landlord's first concern should be whether the property is empty. If so, the landlord will need to make sure that the building's insurance continues to cover the building. If the landlord insures the building, then the position is relatively straightforward. The landlord will need to check whether the building is vacant, and if so, inform their insurers to ensure that the cover continues. If, however, the insurer has additional requirements in order for the insurance cover to remain in place, for example, regular visits to the premises, or if there is an additional premium payable, the position will need to be handled delicately with the insolvency practitioner so as not to waive the right to forfeit, if that is indeed what the landlord wishes to do. If it is the tenant's responsibility to insure the building, the landlord ought to consider contacting the insolvency practitioner to seek their confirmation that the insurers have been informed of the vacant status of the property. This step should, however, be considered with caution if the landlord wishes to forfeit the lease, as the taking of this step may waive the right to forfeit. This takes us neatly to the issue of whether the landlord is able to forfeit the lease and how a landlord needs to tread carefully if this is an option that they wish to explore. This is a decision that the landlord will need to make early on, and I'll explain some of the issues surrounding that now. As most of you will be aware, commercial leases, generally speaking, all include a provision allowing a landlord to forfeit the lease in the event of a tenant's insolvency, or, more commonly, for non-payment of rent. This does, however, need to be handled with care, not only due to any moratorium that may exist, but also so as not to waive the right to forfeit. Both tenant insolvency and non-payment of rent are classified as once and for all breaches of lease, which means that if a landlord knows about the tenant's insolvency, or the rent remains unpaid for the requisite number of days, and the landlord takes a step or steps which treats the lease as continuing, then the right to forfeit the lease for those breaches will be waived. Although when it comes to non-payment of rent, the right to forfeit will arise when the next quarter or the next month's rent remains due for the requisite period. If the landlord wishes to forfeit the lease, then they need to be very careful about the communications they send to the insolvency practitioner, and they must also put a hold on any rent demands, etc. being sent out. They need to contact their agent to ensure that they do not send out demands unless a hold is put on any automatic correspondence and demands, and agents obviously need to act on this straight away. In the case of administration or compulsory winding up, where there is a moratorium in place preventing forfeiture without the insolvency practitioner's consent or without the leave of the court, it may be that the landlord's only request of the insolvency practitioner is whether they will consent to the lease being forfeited. In other words, the landlord will stay quiet about everything else, including increased insurance premiums. If the insolvency practitioner will not agree, then we need to consider whether to make an application to court for leave to forfeit, and we need to think about whether that application is likely to be granted. If it isn't likely to be granted, then the landlord may well disregard the forfeiture option and look at the other options that they have available to them. At this point, I'll take you through some of the relevant case law as to the issues that will be considered by the court when deciding whether to grant leave to forfeit. In the case of a tenant in administration, the test for whether the court will grant leave to forfeit was set out in the case of Re-Atlantic Computer Systems plc in 1992. In that case, the court held that the question of whether those having proprietary rights against the company should be given leave to enforce those rights depended on the circumstances of each case. The circumstances to be considered included 1. The consequences which the grant or refusal of leave would have, 2. The financial position of the company, 3. The period for which the administration order was expected to remain in force, 4. The end result sought to be achieved, 5. The prospects of that result being achieved, and 6. The proprietary rights of the parties concerned. Given that, it was held that the court should adopt a flexible approach. Unfortunately, however, this did not give the landlord much certainty. In the more recent case of SSRL Realizations Limited in administration in 2015, the news was more positive for landlords. In this case, the landlord sought permission to forfeit a lease granted to Signature and Strada Restaurants Limited. The landlord had refused to grant license to the administrators to assign the lease and sought leave to forfeit. The issues before the court were whether the landlord had unreasonably refused license to assign and or whether leave ought to be given to the landlord to forfeit the lease. As to the landlord's refusal to grant license to assign, this was held to be reasonable even though the administrators would have realised somewhere between 1.3 million or 600,000 from an assignment, although there was some dispute about the figures. The court found that there was no real prospect of the landlord's consent being given to the assignment because the proposed assignee was not of sufficient financial standing and no AGA had been offered. The clever landlord had also terminated a licence granted to the tenant personally, which had allowed them to use outside seating. This meant that another possible assignee, Wagamama, who would otherwise have been a suitable assignee and obviously an attractive assignee, had no interest in taking an assignment of the lease. These findings meant that the court was unable to accept that the grant of leave to forfeit would deprive the administrators of realising some £600,000 or more, as the landlord had not unreasonably refused licence to assign and there wasn't a prospective assignee. The argument that the administrators would lose something of value if the court gave leave to forfeit was as a result said to depend on the prospect that the administrators would be able to find some other, as yet unidentified assignee who was willing to pay a premium and to which the landlord could not reasonably refuse licence to assign. In other words, could the administrators find a purchaser of the lease to which the landlord could not reasonably refuse to grant licence to assign, thus meaning that the lease could be sold, realising money for the tenant company. In this case, the court concluded that the purpose of the administration would not be impeded by the granting of permission to the landlord to pursue its proprietary rights, in other words, to forfeit. The court found that there were no grounds to believe that the administrators would be able to achieve a premium by assigning the lease. Whilst the leasehold interest had some potential premium value, the administrators were unable to unlock that value due to the lawful exercise of the landlord's rights. The lessons to be learnt from this case for a landlord wanting to forfeit a lease in an insolvency situation are: 1. To consider whether the lease lawfully permits the landlord to take any action, for example, regarding the use of the premises, which would make it harder for the administrators to assign the lease. In other words, how can the landlord use the terms to its advantage so as to position itself to reasonably refuse license to assign? A wily landlord may find a way, much as they did in the SSRL case. 2. They should carefully consider any application by the insolvency practitioner for license to assign and whether this can be reasonably refused. And thirdly, if license to assign can be refused, whether to make an application to court for leave to forfeit if the insolvency practitioner will not consent to forfeiture. And obviously in that situation, the landlord needs to build up its reasons for why they should be given license to forfeit. I'll now turn to the issue of rent being paid as an expense of the administration. A landlord may decide not to forfeit a lease if they can recover their rent as an expense of the administration. A possible reason for this is that the landlord may not want to become liable for business rates, which they otherwise would if they forfeited. The starting position for whether rent is to be paid, the starting position is that the rent payable by the tenant is a debt which is provable in the administration of a corporate tenant. In other words, unless monies are realised by the administrators, the landlord is unlikely to be paid the rent, even if the administrator will not hand back possession of the premises. A possible saving grace for the landlord is that if the administrator has retained the premises for the purpose of the administration, for example, if the business is still being carried on from the premises, then the landlord can argue that the rent is to be paid as an expense of the administration, and therefore to be paid in priority to other creditors. Following the case of Jervis and others versus Pillar Denton Limited in 2014, the rent will, however, accrue on a day-to-day basis in this situation. In other words, the landlord can only claim the rent as an expense of the administration for the period which the administrators use the premises for the business. This is contrasted with the position when the lease is forfeited, when the full quarter's rent is payable by the tenant, even if the lease is forfeited partway through the quarter. I'll now turn to the landlord's possible options if they cannot or do not wish to forfeit, and the rent is not going to be paid as an expense of the administration. I won't be considering these in any detail, but I will consider them briefly now. Firstly, CRA. This is a topic that I've covered in an earlier webinar, but in brief, CRA replaced the former common law right to distrain. It is a process whereby rent can be recovered from a tenant by seizing their goods and selling them at auction. This is more commonly used when the demised premises contain stock or other tenant's assets which are of value. As Alex has explained, however, there are restrictions on the exercise of CRA, and the individual circumstances will need to be considered depending on whether to, in order to decide whether to adopt this route. Another possible option is drawing down from the deposit. This speaks for itself, and a landlord ought to consider whether it can draw down from the deposit. This will depend both on the form of insolvency process and also the form of the rent deposit deed. If the deposit is structured in the form of a charge, then it's harder to use the deposit. I'm not going to go into this in any more detail, as the position will depend greatly on the terms of the rent deposit deed, and each case will need to be considered on its own facts. Turning now to recovery of rent from a guarantor. Again, this is something I've covered in an earlier webinar, which I will briefly summarise. Obviously, the first point to make is that the terms of the guarantee need to be checked to see whether it allows for recovery in particular circumstances. A point to note, however, is that if the landlord wishes to pursue rent arrears from a former tenant or a guarantor of a former tenant, then the Landlord and Tenant Covenants Act 1995 will apply, and the landlord must serve a notice in the prescribed form on that former tenant and or guarantor of the former tenant within 6 months of the date when the rent became due. If that deadline is missed, then they will not be liable to pay. Please do let me know if you want to listen to our commercial rent arrears webinar, which explains CRA and the guarantor issues in more detail, and we'll be pleased to send you a link for that. One issue that I will take you through in more detail is whether guarantors could be required to take on a new lease. Again, the starting point for this will be the terms of the lease itself. Most modern commercial leases with guarantors contain a provision allowing the landlord to require the guarantor to take a new lease in the event of forfeiture or disclaimer of the lease. If the landlord has waived the right to forfeit, for example because they were more concerned by trying to recover an enhanced premium for insurance, then they may still be able to require the guarantor to take on a lease if there is a disclaimer by the liquidator or trustee in bankruptcy. Liquidators and trustees in bankruptcy have the power to disclaim any interest of the tenant in the lease if it is owner's property. They can disclaim the lease even if it is for a fixed term. The effect of the disclaimer is to end the rights, interests and liabilities of the tenant in respect of the property. The good news for landlords, however, is that it does not operate to release the rights and obligations of any other person. The authority for this is the Hindcastle case. And as a result, if the lease is disclaimed, the liabilities of the guarantor do not end. It is, however, crucial that the landlord understands the effect of the landlord taking back possession of the disclaimed property. If the landlord takes back possession, any third party's liabilities and obligations, in other words, those of the guarantor, will fall away at the point of taking possession. If the landlord wishes to rely on the guarantee, then they must not take back possession, and indeed they are not obliged to do so. Again, they must think carefully before they act. Assuming that a notice of disclaimer is served and the landlord does not take back possession, or if forfeiture takes place, then the trigger for the guarantor to take a new lease is a notice from the landlord. The landlord must ensure that such notice is served within the strict time limit specified in the lease. Otherwise, the right to require the guarantor to take the lease will be lost. You must make sure that you comply with the terms of the lease. Taking a step back, I think that the moral of this webinar has to be that the landlord and their agents have to keep on top of all deadlines, make sure that they put a hold on automatic demands and correspondence, and give careful consideration to their options and the terms of the lease, the rent deposit deed, and any guarantee before they take any action. I'll now hand you back to Alex.
Thank you, Penny. There are some other alternatives for landlords to consider. If the debt is small, then the landlord should consider writing it off for commercial reasons. There may also be a variety of other reasons why a landlord may deem it more appropriate to simply write off the debt, which are fact dependent. For example, if a landlord has another tenant willing to take a lease of the property, the landlord could consider whether to write off the debt and accept a surrender of the current tenancy. Alternatively, a landlord will need to prove any bankruptcy or corporate insolvency procedure by submitting a proof of debt and a claim for losses, although it's unlikely that they will recover much of the money due to them. This should include a future loss of rent claim and any other claims that can be made against the tenant. A landlord must make sure this is done on time. If the landlord wishes to forfeit, however, they must take advice on the issue of waiver before taking such a step. Should the premises be marketed, consider marketing the property for future tenants, but ensure this is not treated as a surrender, and the landlord will wish the rent to continue to accrue. An attempt to re-let, as opposed to actually reletting, does not of itself constitute taking possession and a surrender by operation of law. However, the landlord should confirm in writing that he is only accepting the keys for those purposes.
Right, you're back with me now, just to round things off as to how a tenant's insolvency might be an advantage. Admittedly, it's hard to see how this could be an advantage, but there are at least two possible ways in which it might be. The first obvious possible advantage is that a landlord may be able to require a guarantor to take on a new lease of the premises, as I mentioned earlier. If the landlord carries out their due diligence carefully when granting the lease, that guarantor may well be more valuable as a covenant than the tenant itself. A clear example of this is when a parent company guarantees the obligations of its subsidiary. Assuming that parent company holds all the assets of that group, that is likely to make the landlord a happier person. When granting a lease, therefore, it is important that the guarantors are chosen and vetted thoroughly. Another, less obvious possible benefit is the possibility of the landlord taking back possession of the premises to enable development, sale for development, or the granting of a lease on better terms, or even for the landlord to occupy the premises themselves. This is particularly pertinent when the landlord has granted or acquired their interest in the premises subject to a long commercial lease without a break clause and within the protection of Part 2 of the Landlord and Tenant Act 1954. As many of you may be aware, if it's a Part 2 protected tenancy and the landlord wishes to occupy the premises themselves, they have to have owned their interest in the premises for 5 years before they're able to use that grant of opposition. If they haven't owned it for that long, then they might be stuck with the tenant, unless, of course, they can force a disclaimer of the lease. As to how you can do this, well, the starting point is to try and force the liquidator to disclaim the lease. If the liquidator doesn't appear to be willing to give up the lease, perhaps they think they can realise some value in it, then the landlord can still force their decision by serving notice on the liquidator, requiring them to decide whether they will disclaim the lease. This is done by writing to the liquidator and requiring them to decide whether to disclaim within 28 days. This is a relatively short period of time, particularly when the liquidator is hoping to sell the lease, and it adds to their pressure to make a decision. The reason for this is that they will lose the right to disclaim if they do not make that decision within 28 days, subject, of course, to the power of the court to extend that period. If it is timed correctly, then you may be lucky enough to put enough pressure on the liquidator to force them to make a decision to disclaim the lease. This would mean that the landlord can take back possession without having to oppose 1954 Act renewal, and without the obligation to pay statutory compensation, on a non-fault grounds. In larger properties with a long-standing tenant, this can be of considerable financial advantage, and it's certainly something that I've been on the receiving end of. If that is something that you wish to do, please do take advice on the form of the notice to be served on the insolvency practitioner. Now, that's all we wanted to go over with you today on this vast subject. We have had one question, which is whether we can send over the notes, and I'd be happy to do that for anyone that wants us to do so. If anyone's got any more questions, please do send them over now. Otherwise, we'll sign off for today. And if you'd like to contact us, then please do so. My email address is pi@debenhamsottaway.co.uk. I'll just give you a second if there's anyone else that wants to ask anything. If not, we will sign off. No, I think that's it. So thank you very much for joining us. It's been a pleasure, and we look forward to hearing from you soon.